What's going on, everybody? We are back with another podcast. You know, a lot of people have been asking questions about hidden costs.
Yeah.
What's the transfer process like and why it takes so long? Well, we have answered you. We have got Brett Smith in the building.
Taine, your machine.
Nice to have you here.
Yeah, lovely to be
and
here.
we're going to be answering a lot of questions on what the transfer process is like and all of that. So
Yeah.
like, follow, and subscribe. And Brett, why don't you introduce yourself? Why don't you give a brief about Brett Smith Attorneys, and then we'll take it from
100%.
there.
Thanks, Taine.
Yeah.
So my name's Brett. I'm from Brett Smith Attorneys and McGlashan McEwen Inc. People actually often ask me, what am I going on about when I say McGlashan McEwen Inc. So the story is about 4 years ago, I started Brett Smith Attorneys, and about 3 years ago, I purchased McGlashan McEwen Inc. Sorry.
No,
You're
that's
right.
fine. Go.
And about 3 years ago, I purchased McGlashan McEwen Inc. So currently, I'm running the two businesses from one office just down the road. As a firm, we specialize particularly in property transfers, namely conveyancing. People often wonder what exactly is a conveyancer, and really, they often think that we're not attorneys. But rather, we are an attorney, but we are attorneys that have specialized in property law. Okay. Taking it a step further, people often ask, what is a notary? Because as you can see, attorneys, conveyancers, notaries.
Yeah.
Notaries are also attorneys, but we're attorneys that have specialized in specific types of rights. An example of those rights are your matrimonial rights. So we execute antenuptial contracts in relation to those rights. But more particularly in the property law space, where your notary would come into play is in a situation where you're selling a section in a sectional title scheme, and the relevant owner of that section has the right. Remember, I said notaries deal with rights. So the relevant owner has the right to use and enjoy something called an exclusive use area. So a notary will then convey, you can call it, or the correct word is cede, the right to use and enjoy the particular exclusive use area, while the conveyancer will transfer the section itself. Sorry, I don't mean to get too technical on that.
No.
So yeah, we've really been enjoying ourselves over the last little while, and we've certainly been blessed. Nice steady growth. We've got a lovely team behind us, and really what we're trying to do is, as you know, glorify God in all that we do, and we're slowly building towards that mark. Like I said, lovely team, lots of young, energetic team members, guys that are really committed and buying into, I like to call the dream. Our fundamental principles are really self-discipline, humility, and faith, and I believe that by clinging to those, we have seen some lovely traction to date, and I believe that we should continue to see that same traction.
Sure.
So yeah, that's really what we're about. Me personally, can I unpack that briefly? My journey to get to this point has been a lovely one, and I was fortunate to, some of my formative years, I spent them in Pietermaritzburg, going into the deeds office every single day, really learning the nitty-gritty of what's happening behind the scenes in a conveyancing transaction. So that sort of expertise is something that you don't often get not being in Pietermaritzburg. So for those of you who don't know, the deeds office for the whole of KwaZulu-Natal is situated in Pietermaritzburg. So if you're not practicing as a conveyancer in Pietermaritzburg, you don't actually get that exposure. So it was lovely to have done my training years in Pietermaritzburg, to pop in there daily, to figure out, deal with the deeds office staff, know exactly what's happening when we send our deeds up to Pietermaritzburg for lodgement, which we'll unpack a little bit later, and see the process that follows behind the scenes, so we can keep you guys properly informed throughout the process.
Yeah, definitely.
Beautiful.
So
Excellent.
obviously you spoke about the transfer process, which
Yes.
we're going to unpack, but what's the biggest mistake buyers and sellers make during a transfer process?
Yeah, so that's a bit of a loaded question.
Yeah.
The biggest mistake, there's a couple kind of fundamental mistakes, and I see your question is really directed at the transfer process. So we're focusing at the stage after the sale agreement has been signed, but I think it's difficult to to think away the sale agreement period itself, because a lot of the issues that play out in the transfer process are as a result of things at the sale agreement stage, as you know.
Yeah.
So I think one of the massive mistakes that guys make, and it's a common one, or maybe not a mistake or misunderstanding, is often the general feeling in the general public is that the footstewards clause means absolutely nothing.
Yes.
You'll hear it's a common it's a common misunderstanding that if you speak to anyone, if you go and engage in the community and you talk to them about footstewards, they'll often say, "Oh no, that's not worth the paper it's written on." But rather that is a very binding clause and a very onerous clause, and it must be treated with complete respect. In your ordinary footstewards clause, and just as a side note, the footstewards clause derives from our Roman Dutch law background, and it quite literally means footstewards, foot push, foot push, and that's to test the quality of something. They used to push their foot against whatever the relevant item was to see whether it was sturdy and strong. And basically what footstewards then means in your modern day society is, or in our current law, is you buying the relevant thing as is, okay, as it stands, including all latent and patent defects. So that will include defects that are completely visible and defects that are invisible. Your footstewards clause, your standard one in most of your sale agreements, will go a step further and say that the purchaser warrants that they've duly inspected the property to their satisfaction, and that they are satisfied with their inspection and to proceed with the relevant sale, including all latent and patent defects. So there's not only the description of the footstewards clause, but it even says that the purchaser has made their relevant inspections. So like going back to kind of what preempted that statement is, a lot of the time your purchasers think, footstewards means nothing, I don't care, I'm just going to sign this thing. But 9 times out of 10, it's going to completely apply, and they're going to find themselves in quite a difficult scenario when they do pick up on defects and they had this wrong understanding all along. Okay, in about 2019, I think it was 2019, you'll know better, the Property Practitioners Act came out, and really what that required all of us to do when closing a deal is for the seller to complete a mandatory declaration. So that's them declaring any defects that they have picked up in the property, and it's as far as they're aware. So there's they do their best to complete it, but key from a seller perspective, because we unpacked one of the risks and mistakes that the purchasers make, because often we got to steer the purchasers back to the footstewards clause, which is a sad scenario. But likewise, if there's a clear and obvious mistake, then the seller needs to be properly disclosing that in their mandatory disclosure form. That's the point of the mandatory disclosure form. The issue then, if they fail to disclose it, is if we go back to our footstewards clause, sorry, I don't mean to overcomplicate things. If we go back to our footstewards clause, the only way that you can validly unwind or unravel the footstewards clause is if the seller has fraudulently not disclosed something in order to, you could say, coerce you into the deal. So they failed to disclose a material fact in order to get you into the deal. Now, that's generally difficult to prove in the ordinary course, but if there's a mandatory disclosure and there's a massive hole in this wall here, and I failed to put it in the mandatory disclosure, that's pretty much clear-cut evidence that I would have known that, and I've failed to disclose it in this document, thereby proving that I haven't disclosed it, and it's definitely, I wouldn't say definitely, because there's a lot of room for argument, but there's more scope to prove that I fraudulently failed to disclose it in order to persuade you into the deal. So those are some massive mistakes that guys make. There's one other one linked to the sale agreement as well that we see. I've got a basic idea of the further questions that you're going to answer. I don't want to touch on that stuff yet, but when guys word in special conditions, okay, so in your sale agreement, it might say, as a seller, you'll say, seller to repair fence, okay? 3 or 4 words, sounds nice and easy, but often we see that turning into a huge fight because it doesn't describe what's the spec of the fence repair, okay? Because purchasers thinking they're about to get a clear view fence, a beautiful clear view fence, but sellers thinking I'm going to use some weld mesh and some barbed wire. Do you know what I mean? So there needs to be a clear meeting of the minds on those very material terms, because at the time of closing, one person might not be thinking what the other person is thinking, and we end up in a big fight. Secondly to that, there needs to be a timeline to those special conditions. So by when must that fence be fixed? What is the spec of the fence? And who determines whether that spec was fulfilled? Okay. So yeah, I mean, we deal with this kind of thing regularly, and what we like to do to kind of be safe is actually get the purchaser to propose what they want. Okay. It's not, you know, it's not in every case, but it's quite a user-friendly approach, that because then, you know, after the fact, if it's not done to spec, the purchaser can't really complain about their own fence guy or handyman or whatever the case may be.
Sure.
So other material mistakes during that transfer process, I think we're going to touch on a few of them just now, but I think that's all good for now.
Footstoots is a big clause.
100%.
And also adding special conditions, making sure both parties know exactly. So I think in South Africa, a lot of the buyers and sellers always ask, like, why does the transfer process take so long? And what actually happens behind the scenes? Yes.
Okay. The transfer process. So you might need to make me not take too much time here, because I'm very passionate about this, and I actually present very regularly on the entire transfer process. So the transfer process, really what Taine's referring to, is from the date of signing the relevant sale agreement to the date of the final milestone being registration of transfer in the deeds office. What's happening in between there, and why does it take so long? I like to say, firstly, it doesn't take that long when you use Brett-Smith attorneys.
There we go.
But as an aside, so in the ordinary course in KZN, we generally quote 3 months to get this whole process done. More recently, it's been taking 2 months, and sometimes even less. You know, on occasions, we'll get a transfer through in 41 calendar days, which is basically a month, which is lovely. But key to understanding, because Dan's question is about what happens behind the scenes, key to understanding that is to know that there's actually more than one attorney involved in any single conveyancing transaction. So if you are what is commonly known as the conveyancer, you'll really be fulfilling the role as the transferring attorney. So everything you've heard up to this point has been a reference to what the transferring attorney does. But if there is the seller, so if the seller's selling the property and they have a bond over their property that needs to be cancelled simultaneously with the transfer. So when they bought, they used the bond to buy, okay? That is then another attorney in the mix. So that's called the bond cancellation attorney. And then if the new purchaser is using a bond to fund their purchase, so they've gone to the bank and they've got a bond in order to buy the property, there's another attorney involved called the bond attorney. So straight away we see there's 3 different attorneys involved, okay? The transferring attorney, which in this example is us, is kind of like the team captain. So we are chasing up the bond attorneys and the bond cancellation attorneys to make sure that throughout this whole process, when it's time to lodge in the Pietermaritzburg deeds office, they're ready. Okay. At the point of lodgement, and we'll unpack some of the steps to get there, but at the point of lodgement, me as the transferring attorney talk to my friend, the bond attorney, and I talk to my other friend, the bond cancellation attorney, and we lodge simultaneously in the deeds office. We all link up and we actually walk into the deeds office on the same day. I have my title deeds, they have their bond, they have their bond cancellation, and we link them all into a couple folders. They're called lodgement jackets, and they're all numbered to show that they're all linked, and they go in as a batch. Okay, so there's quite a lot in relation to ensuring that's properly collaborated, but really there's no excuse for there to be any delays with your bond attorney or any delays with your bond cancellation attorney. And the reason why I say that is because your bond attorney and your bond cancellation attorney are operating completely in the private realm, okay? And what I mean by that is they have no state intervention in their process, because we're going to get to our transferring attorney process and you'll see that the state is involved, which ultimately is the cause of the delays. But your bond attorneys, the people involved there are the bank who funded the purchase, together with the relevant purchaser.
Yeah.
That's the only people involved. So they're very user-friendly, they should be, and that's a quick and efficient process. So there's no reason why that should take long. Bond cancellation, same story.
Yeah.
Bank and seller, easy. Transferring attorney, we have, as the transferring attorney, you have two state entities involved, namely SARS, because on any single transaction, you need something called a transfer duty receipt or a transfer duty exemption receipt if it is a VATable transaction. Yeah. The other thing that we need from a government perspective or state perspective is the legendary rates clearance certificate.
Which can take a while.
So that is, SARS is generally not an issue from a delay perspective. SARS, all things being equal, if we apply for our transfer duty application, the assessment should come through same day. If we pay that day, we should get our receipt. Yeah. So within a day. So SARS is generally not an issue. If they have any questions, if SARS have any questions, they generally, their questions come in various forms, but they'll ask for things like copy of the sale agreement, valuations from two independent valuations from estate agents and that sort of thing. And they'll ask those questions when they think they're being shortchanged.
Okay.
So they'll say, you're selling below what the fair market value is. Transfer duties is payable on the fair market value. So go and get us some independent valuation so we can see that you're charging the correct amount, and then we can bill you the correct amount.
Yes.
See the thinking?
Yeah.
So that's the one version when they query. The other version when they query is when we're doing VATable transactions. That's going to be a whole nother talk, I think, between us when we do VATable transactions. Those are technical and they're a lovely thing. I have quite a commercial background, so I love putting those sorts of deals together, achieving your sales as going concerns. There's lots to unpack there, so we won't go further on that. But that's another example of a transfer duty exemption receipt. Then the big one, rates clearance certificate. So for every single property transfer, a rates clearance certificate needs to be issued by the relevant municipality where we're based in Durban. We use the eThekwini municipality for all of our transactions. They have varying degrees of efficiency. We try our best. I mean, we pop in there extremely regularly to try and chase things along. But that race clearance certificate is at the heart of any and all delays in a conveyancing transaction. The process there for eThekwini specifically is you apply for your rates figures. They have the rates hub in Durban Centre. They then outsource to their electricity department and their water department, and they need to go and do their water meter readings and their electricity meter readings, and then do assessed figures. So what that means is they estimate what the figures or the fees will be payable over the upcoming 3 months, and they send those back to the hub in eThekwini, and then they send the full set of figures, rates, which is coming from eThekwini, plus water department, plus electrical department. All the figures come to us, and we'll see what's currently outstanding on your relevant rates account, and then what is due for the upcoming 3 months. So key to understanding, and I think I should unpack this a little bit because it's important. What they're actually doing there and what a rates clearance certificate actually means is it's a certificate to say for the upcoming 3 months, it does vary. So the figures are valid for a month, and then the certificate is valid for 60 days. So the whole period is 3 months. For this period, no rates, no lights, no water, nothing's due to the municipality because you've made an advance payment up front, okay? The seller will pay this full amount, okay? We make provision for it from the purchaser, but the seller will pay the full amount up front, and the reason being is if the sale for any reason fails and we've used some of the purchaser's money to pay these figures, then obviously we've got a problem because now the property still belongs to the seller. So that's quite key to understand. Do you want me to talk about apportioning?
You can, yeah. Go ahead.
I don't want to talk too much, but so and how, particularly in eThekwini, I'll briefly unpack this, but in eThekwini we have a rates account and you have something called a consolidation account, okay? Yeah. Your rates account sticks with the property, okay? So no matter what, the rates account will be linked to that property. So what I mean by that is the purchaser is going to inherit that account, okay? Your consolidated billing account sticks with the person, okay? So when the seller goes, that's his account still, okay? Yeah. So do you see, by that reasoning alone, we as the conveyancers will apportion the rates because it's sticking with the property and the purchaser is going to inherit it. So we need to make sure that it's properly paid up and that the allocation towards the purchaser or the contribution by the purchaser is correctly allocated towards him. So just by means of figures, if we get 3 months worth of rates figures, like I said earlier, and registration of transfer takes place at 2 months, obviously the purchaser is liable for 1 month, but the seller's paid the full 3 months up front. What we then do is we've made provision for it, and we as the conveyancers can then apportion that. So we take, when we're doing our final account, we've made provision for the purchaser to contribute. We take a month's worth of rates and pay it over to the seller. Do you follow the thinking? Because the seller's paid for 3 months in advance to the municipality, we then refund the seller directly by the purchaser or from the purchaser. That doesn't apply with your consolidated billing. So your lights and water, that is a separate account that sticks with the relevant seller when he goes. The purchaser needs to go in and open their own consolidated billing account. And with that, and what that means is that we as the conveyancers can't apportion that figure. So that's for the seller to now go and close his account and apply for a refund directly from the municipality. And it's for the purchaser to go and open his account and be back billed. There's no apportioning on our side. I hope that's not too technical.
That's why we need a part 2. There's a lot to unpack, obviously, in the process.
Sorry. So that's our major delay, being the rates department. And ultimately, then, like I said, we follow that process, get the parties in to sign, make sure the bond attorneys are en route, make sure the cancellation attorneys are en route, and we have our rates clearance certificate, our transfer duty receipt, a couple other documents, and we all get together in Maritzburg and then lodge. So there's a whole lot of balls rolling in the background the whole time, and we're pushing them simultaneously. If it's a sectional title scheme, there's also the body corporate element, and we need to get levy clearance certificate. We need to make provision if there's a levy stabilization fee. We need to make provision for that. There's quite a few moving parts. If the municipality comes to the party, and that we see because we do lots of transfers all over the country, and sometimes some of these outlying municipalities are super efficient, you technically should be able to do a transfer in 3 weeks. Yeah, as simple as that.
There we go. Municipality, 3 weeks. Come on. But last and final question is, what are the hidden costs of buying or selling a property that often catch people by surprise?
Okay, the hidden costs shouldn't be as hidden as we think. We want to be informed sellers and buyers. So I always encourage guys, we have stacks of material that you can circulate, and you can go and look on our website. But I even encourage guys, you can go on to Google and just type in transfer cost calculator, and it will show you not exactly, but a decent estimate of what you may pay in order to buy a property. Key to that, the transferring fees, so as the conveyancer, you charge transferring fees. They link to a government tariff, so we're told what we're allowed to bill the client. A fundamental kind of misunderstanding is there's transferring fees, which is what comes to us, and then there's transfer duties, which is what goes to SARS.
Correct.
Now, the transferring fee, which is what comes to us, goes on a diminishing scale. So proportionately to the value of the transaction, as the value gets bigger, obviously our fee is increasing, but it's at a diminishing rate. Don't want to overcomplicate that. But transfer duties does the exact opposite. So so transfer duty starts currently at about 1,250, then you start paying transfer duties at 3%. But as it gets bigger, the percentage you pay of transfer duties also gets bigger. So it's exponential. Okay. Key to that whole process, and a common misunderstanding, is that people think that when we say to them, oh, we'll give you a 20% discount, they look at the bottom figure of their pro forma or their quotation and say it's 100,000 Rand, including transfer duties. They think, okay, I'm getting 20,000 Rand off my account. But no, of the long list, 80,000 is going to SARS, for example, and 20,000 is coming to us. So the discount will only apply to the 20,000, obviously, because we can't discount what we're giving to SARS.
No, exactly.
So that's a massive one that people, it's a trap that guys often fall into. We try to make it very clear that that the discount only applies to our fee, because obviously we can't discount SARS. And to make it even more clear, more often than not, we propose the discount in a Rand value. So it's not a percentage to cause any form of confusion. Rather, it's you're going to get a 10,000 Rand discount, for example. Then they know exactly what they can deduct, and there's no confusion. The other thing that often catches guys is that, with my analogy earlier of transferring attorney, bond cancellation attorney, is they all have separate costs. So your bond attorney, you may cater for your transfer cost to your transferring attorney, but your bond attorney, their fee is actually on the tariff the same as ours. So if you're buying a 1 million Rand property and the conveyancing fee on that is 15,000 Rand, if you're getting a 1 million Rand bond, the bond fee is 15,000 Rand, okay? More often than not, though, if you're a first-time buyer, the bank will impose on the bond attorney, if I'm acting in my capacity as bond attorney, that I must give you a 50% discount. So you must bear that in mind when you're engaging with whoever you're engaging with, that if you are a first-time buyer, 9 times out of 10, you'll be able to qualify for a 50% discount on your bond fees, which is a big winner. Just one more thing on unexpected costs. From a seller perspective, if you bought your property with a bond and now you're needing to cancel your bond simultaneously with your sale, even if your bond is at nil and it's been sitting at nil for many years, you still have to instruct a bond cancellation attorney to cancel your bond. People get very upset about this. That is ordinarily in the region of about 6,000 Rand to cancel your bond. Not only that, there's also another fee that can get triggered by the bank called an early termination charge. And what that is to say is they're billing you for a situation where you have entered into a loan agreement with the bank for installments over a 20-year period, but you settle it in 10, and they had anticipated making interest for 20 years, so then they charge you a penalty for cancelling early. That's ordinarily calculated as one full month's bond repayment is equal to the penalty, and it's on a diminishing pro rata scale. So if you give, in relation to that early termination of your bond, you are required to give notice to the bank that you anticipate cancelling your bond. Okay, otherwise you'll fall foul of that clause and you'll get stung with the early termination penalty fee, which, as I said, equates usually to 1 month's bond repayment. The termination period that you need to give, or the period required post-termination pre-cancellation, is 3 months, okay? So what I always say to guys is, if they're in negotiations with, for example, Taine, or with purchasers, or they're anticipating a sale soon, give notice to your bank that you're going to cancel that bond shortly. Because earlier I might have referenced the diminishing scale of that penalty fee, or the penalty fee being on a pro rata basis. What I mean is, if I give notice now and I had to cancel today, I'd be liable for a full month's penalty. But if I give notice now and the bond gets cancelled because the transfer goes through 2 months later, I'm only liable for 1/3 penalty. Okay, so as you dig into your notice or cancellation notice period, the portion you pay as a cancellation fee reduces. Are you following the thinking?
Definitely.
Yeah, so that's pretty much that story. Hey?
Sure. So why don't you let that camera know where they can find you, your email, all of that, and why they should use you?
100%. I hope you're feeling positively informed from this morning. We are located at 22 on Main in Hillcrest, KZN, South Africa, for all our
overseas viewers.
Overseas viewers. We're a super user-friendly experience. Everyone that engages with us is generally very happy. We're completely available on all platforms. Particularly, guys enjoy our WhatsApp availability. So any clients, as soon as they reach out to us, or as soon as we receive any correspondence, we give them a phone call immediately to establish that kind of friendly relationship, and then we're available on WhatsApp thereafter. We obviously pride ourselves on transparency, but also efficiency. I mean, in the ordinary course, like I said earlier, we're doing transfers in 2 months, sometimes a bit less, which is faster than most of our competitors. And yeah, we've got endless testimonials and positive reviews from 4 years of happy clients. So we would appreciate you guys to join that team of happy clients.
Cool.
Excellent.
Well, thanks, Brett. Thank you so much. Appreciate it.
Your beauty.
Thanks so much for watching. Let us know if you want a part 2. I think there's a lot more to unpack in this process and actually dive a bit deeper. But like, follow, and subscribe, and we'll see you in the next video. Goodbye.
Awesome.